Oh, yeah, it's like driving. That's exactly right. Yeah, just go to, yeah, I'm not teaching.
But,
It's gonna be
Mr. Worley, I have a copy for you if you want one.
okay. What caliber?
Mr. Howard, here are your copies of your jury charges you submitted.
Thank you, Judge.
Thank you.
You didn't want to include these, Judge?
I'm sorry?
You didn't want to include ours?
No. Mr. DePutis, if you could get Mr. Worley, the court is ready to discuss the charge.
Yeah, yeah.
Thank you.
I'm at your beck and call. Or is it beckon to call?
I don't know.
Because beckon to call kind of sounds like it makes sense. I don't know what a beck
Hey, I
is.
appreciate your delay tactic, but here comes Mr.
Oh, here he is right here, Joe.
Yes.
Let's talk about the etymology of beck and call.
All right. All right, we're back on the record, in this case, outside the presence and jury, bless you. Outside the presence and jury, outside the presence of the jury. Does the state have any objections to the court charge?
No. Oh, wait, hold on. Yes, I'm sorry.
Okay.
Yeah, Judge, I do have an objection to the apparent danger paragraph. I believe that, let's see. Start here. I believe that the apparent danger, well, that's what I'm trying to figure out, where exactly it starts.
It's on page 7. Page 7.
Okay, it starts on page 6. It's not necessarily an actual attack or attempted attack.
Right.
Judge, my objection is that I don't believe that this particular paragraph has a basis in statute, and I believe that the charge should only contain statutory approved language. It's probably the longest instruction in the charge, and I believe that it can be viewed as an improper comment on the evidence by the judge. So I would ask that the apparent danger, I guess that's 3 paragraphs, be removed.
And what says the defense on the issue of apparent danger?
Judge, not all charges, not all paragraphs that go into a charge are directly from statute. Some of them.
I'm so sorry, the computer is gonna lock me out, I've gotta go get my
Okay.
stupid key.
No worries.
I hate when it does that on my phone. I hate when it does that on my phone. It's really hard to check your emails while you're driving if you have to hold that.
Hey, Jay, I think you should be doing that, buddy.
It's on CC 637. We gotta go.
I don't think you should be doing it. Just because I
That's
care.
it, yeah, that's it.
It's really hard to do that thing I
Great,
never do.
great, great. All right, same here.
Mr. Howard, you may continue, sir.
Thank you, Judge. Not every sentence or paragraph that goes into a jury charge is directly in statute. This logically arises from the idea of reasonableness and standing in the shoes of the accused at the time, based on his perceptions in that moment, whether or not the belief was reasonable. So, I mean, that in and of itself has the logic of what you're just stating in a charge that frequently appears in many self-defense cases, because a person need not be correct with the benefit of hindsight that they were actually being attacked, but if it was reasonable at the time in their shoes based on what they knew and thought and saw in that moment, if the jury believes that's reasonable, that's enough. And so I think the apparent danger language contained on page 6 going into page 7 is correct and appropriate, and I believe it should stay in the charge. And I think that the state can argue that it's not reasonable. They can argue that there was no attack, or that there turned out not to be a weapon. They can make all those arguments. I think those are perfectly proper arguments. But I do think it's vital and appropriate to explain apparent danger in the context of reasonable fear of immediate threat.
Well, I think it particularly applies in this case where the complainant was not armed with any apparent deadly weapon.
And that's, Judge, why I believe it's an impermissible comment on the facts. I believe that what the courts have talked about is that it is not error to keep that out, as long as we have instructed the jury properly on that deadly force is justified if he reasonably believes that the deceased was using attempted to use unlawful deadly force against her at the time of the shooting, and if she reasonably believed that the use of force and the degree of force used were immediately necessary to protect herself against their use or attempted use of deadly force. I believe that is in the charge. That covers that situation. Certainly, the defense counsel can argue that language would indicate that if it's a reasonable belief that he has to defend himself, that they should consider that self-defense. I think to add the extra language, the extra non-statutory language in is, again, especially in a case where we know that the complainant was unarmed, it is an improper comment on the evidence, because it's stating, hey, you know, he doesn't have to be armed here in order for this to be self-defense. He could already make that argument based upon the self-defense that is actually in the statute.
In response, Judge, I mean, what the state has cited is, I assume a case, he didn't cite a case, but it sounded like he was citing a case that, and I don't mean that snarkily, saying that it is not error to keep it out as long as you keep something in, but he's clearly not stating that it is error to put it in. He keeps saying that it's an improper comment, but he's not citing that a Court of Appeals or CCA has said that it is an improper comment on the weight of the evidence, and therefore would be error to include. It just defies logic to say defense counsel could argue this, but to put it in the charge is somehow impermissible. If I can argue it, then I don't see the problem with explaining the law to the jury. It would be different if you were saying the court finds it reasonable, or says there was a weapon, or jury thought there was a weapon. An actual comment on the weight of the evidence that this defense has proved something or the state has proved something would be a totally different matter. But to state that a person has a right to defend themselves if they reasonably thought, that is completely appropriate language.
Judge, I have a case here, it's Walters v. State, 247 Southwest 3rd.
Hold on, 247 Southwest 3rd.
Yes, ma'am. It says it's on page 204, and then 211 through 12. And what it states is, thus, under the Geisberg rationale, we hold that, generally speaking, neither the defendant nor the state is entitled to a special jury instruction relating to a statutory offense or defense if that instruction, 1, is not grounded in the penal code, 2, is covered by the general charge to the jury, and 3, focuses the jury's attention on a specific type of evidence that may support an element of an offense or a defense. In such a case, the non-statutory instruction would constitute a prohibited comment on the weight of the evidence. And I believe that's the situation here, Judge. Again, it is covered by the statutory definition of self-defense. That if he reasonably believes that he must defend himself from an unlawful use of deadly force, that he can use deadly force in return. It says 2007. It's from the Court of Criminal Appeals.
What date specifically in 07?
It just says Tex Crim Act 2007. I've got
Because
247 Southwest 3rd.
Well, apparent danger came in on or after 9/1 of 2007.
Well, where? I mean, I'm not aware of apparent danger being in any statute. If I'm wrong about that, then.
Judge, if I may, Jordan v. State, which is 593 Southwest 3rd, 340. It's a Court of Criminal Appeals case decided February 5th of 2020. Endorsed use of apparent danger. Person is justified in using force against another when and to the degree he reasonably believes the force is immediately necessary, et cetera, et cetera. Person is justified using force he reasonably believes the force is immediately necessary. The evidence does not have to show that the victim was actually using or attempting to use unlawful deadly force, because a person has the right to defend himself from apparent danger as he reasonably apprehends it. Quoting Hamill v. State, which is a 1996 opinion, but this is Jordan v. State from the CCA in 2020, endorsing apparent danger as a completely appropriate instruction. And obviously a 2020 would overrule a 2007 about it not being statutory language. Presumably the CCA was aware of its opinion from 2007 when it endorsed something that wasn't, statutorily backed 13 years later.
Okay. All right.
When was that from?
That was February 5th of 2020.
What was the style of that case?
It was a 593.
I got that one, we need the name.
Oh, I'm sorry, Jordan v. State.
Thank you.
Yes, Judge.
Okay. Does the state have any other objections to the court's charge?
No.
What objections does the defense have?
None, Your Honor.
I cannot believe that.
Well, Judge, I would prefer you use my charge, but your charge is fantastic.
Oh, yes, flattered. All right. I'll give you 30 minutes aside. Will the state open?
Yes, sir.
How much of a warning would you like?
I'm sorry.
I'm going to open. How much time are we going to do, did you say?
30 minutes.
Let me know, Judge, when I've used 10 minutes, please.
Okay. Well, who's opening and who's closing?
I'm going to open.
And you're closing. Okay. How much of a warning would you like when
2 minutes.
2 minutes left? All right. What kind of warning would you like, Mr. Howard?
At the 15-minute mark, Judge, the halfway.
Okay.
Unless I could persuade the court to give me more time.
You think you're going to use more than 30 minutes?
If I could have 40, that would be ideal.
I will give you 40 minutes if you think you're going to use it.
Yes,
But I certainly, if you want 40, I'll give you 40.
thank you, Judge.
Sure. And I look forward to getting some of that back.
I will do everything I can, Judge.
That's all right. If you want to use 40, I'm not going to stop you. All right, then I am overruling the state's objection to the apparent danger charge. Okay, we are ready for the jury.
No, but that's how it's supposed to be. It's going to
The attackers.
Oh.
Just the, yeah. Thank you.
All right, ladies and gentlemen of the gallery, we are at the end. We will have closing arguments. If the attorneys say something you don't like, that is simply too bad. You are still and hereby ordered that you must maintain your decorum no matter what is said during closing arguments. And I certainly appreciate your decorum, maturity in this matter. especially goes for you, Mr. Billings. And Detective Sid. And Mr. Moyer. We're ready.
All rise.
You may be seated. All right, the defense having rested, what says the state?
State closes, Your Honor.
And what says the defense?
The defense closes, Your Honor.
All right, ladies and gentlemen of the jury, you have now heard all the evidence that you are going to in this case. The court has been working diligently to prepare the court's charge to the jury. This contains all of the law that you are to apply to the evidence in this case. I will now read it to you. You do not have to memorize what I'm reading to you. This court's charge goes back to the jury room with you. Court's charge to the jury. Members of the jury, the defendant, Jordi Jose Estrada, has been charged by indictment with the felony offense of murder, alleged to have been committed on or about the 23rd day of January 2020 in Dallas County, Texas. To this charge, the defendant has entered a plea of not guilty. Offense definitions. Our law provides that a person commits the offense of murder if he intentionally or knowingly causes the death of an individual, or if he intends to cause serious bodily injury and commits an act clearly dangerous to human life that causes the death of an individual. Term definitions. An act means a bodily movement, whether voluntary or involuntary, and includes speech. Person means an individual. Individual means a human being who is alive. Deadly weapon means a firearm or anything manifestly designed, made, or adapted for the purpose of inflicting death or serious bodily injury, or anything that, in the manner of its use or intended use, is capable of causing death or serious bodily injury. Firearm means any device designed, made, or adapted to expel a projectile through a barrel by using the energy generated by an explosion or burning substance, or any device readily convertible to that use. Bodily injury means physical pain, illness, or any impairment of physical condition. Serious bodily injury means bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of function of any bodily member or organ. Mental state definitions. A person acts intentionally or with intent with respect to a result of his conduct when it is his conscious objective or desire to cause the result. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause a result. Voluntary conduct. You are instructed that a person commits an offense only if he voluntarily engages in conduct including an act, omission, or possession. Conduct is not rendered involuntary merely because the person did not intend the results of his conduct. Therefore, if you believe from the evidence beyond a reasonable doubt that on the occasion in question the defendant, Jordi Jose Estrada, did cause the death of Octavio Velasquez by shooting deceased with a firearm, a deadly weapon, as alleged in the indictment, but you further believe from the evidence, or you have a reasonable doubt thereof, that the death was a result of an accident and not the result of the voluntary act or conduct of the defendant, you will acquit the defendant and say by your verdict, not guilty. Application of the law to the evidence. Now, if you find from the evidence beyond a reasonable doubt that on or about the 23rd day of January 2022 in Dallas County, Texas, the defendant, Jordi Jose Estrada, did unlawfully, then and there, intentionally or knowingly cause the death of Octavio Velasquez, an individual, hereinafter called deceased, by shooting deceased with a firearm, a deadly weapon, or if you find from the evidence beyond a reasonable doubt that on or about the 23rd day of January 2022 in Dallas County, Texas, the defendant, Jordi Jose Estrada, with intent to cause serious bodily injury to Octavio Velasquez, did unlawfully then and there commit an act clearly dangerous to human life by shooting deceased with a firearm, a deadly weapon, and did thereby cause the death of Octavio Velasquez, an individual, then you will find the defendant guilty as charged in the indictment. If you do not so find, or if you have a reasonable doubt thereof, you will acquit the defendant and say by your verdict, not guilty. If you do so find the defendant guilty of the offense of murder as charged herein, you will next go on to consider the following applicable statutory defense: self-defense instruction. Under our law, a person is justified in using force against another in self-defense when and to the degree he reasonably believes the force is immediately necessary to protect himself against the other's use or attempted use of unlawful force. The use of force against another is not justified, 1, in response to verbal provocation alone, or 2, if the actor, defendant, provoked the other's use or attempted use of unlawful force, unless the actor abandons the encounter or clearly communicates to the other his intent to do so, reasonably believing he cannot safely abandon the encounter, and the other, complainant, nevertheless continues or attempts to use unlawful force against the actor. A person is justified in using deadly force against another if he would be justified in using force against another in the first place, as set out above, and when he reasonably believes that such deadly force is immediately necessary to protect himself against the other's use or attempted use of unlawful deadly force, or to prevent the other's imminent commission of aggravated kidnapping, murder, sexual assault, aggravated sexual assault, robbery, or aggravated robbery. The term reasonable belief, as used herein, means a belief that would be held by an ordinary and prudent person in the same circumstances as the defendant. The term deadly force, as used herein, means force that is intended or known by the person using it to cause, or in the manner of its use or intended use, is capable of causing death or serious bodily injury. The defendant's belief that deadly force was immediately necessary is presumed to be reasonable in certain situations. If the defendant, 1, knew or had reason to believe that the person or persons against whom deadly force was used did, A, unlawfully and with force enter or was attempting to enter unlawfully and with force the defendant's occupied habitation, vehicle, or place of business or employment, or B, unlawfully and with force removed or was attempting to remove unlawfully and with force the defendant from the defendant's habitation, vehicle, place of business, or employment, or C, was committing or attempting to commit aggravated kidnapping, murder, sexual assault, aggravated sexual assault, robbery, or aggravated robbery. And the defendant did not provoke the person or persons against whom the deadly force was used, and the defendant was not otherwise engaged in criminal activity other than a Class C misdemeanor that is in violation of law or ordinance regulating traffic at the time the force was used. This presumption that deadly force was immediately necessary applies unless the state proves beyond a reasonable doubt that the facts or circumstances giving rise to the presumption, as listed above, do not exist. If the state fails to prove beyond a reasonable doubt that the facts giving rise to the presumption do not exist, you must find that the presumption does exist. Even though you may find that the presumption does not exist, the state must prove beyond a reasonable doubt that each of the elements of the offense charged. If you have a reasonable doubt as to whether the presumed fact or circumstances exist, the presumption applies, and you must consider the presumed fact and circumstances to exist. A person who, 1, has a right to be present at the location where deadly force is used, 2, who has not provoked the person against whom the deadly force is used, and 3, who is not engaged in criminal activity at the time the deadly force is used, is not required to retreat before using deadly force to defend himself. If you find from the evidence that the defendant was such a person, or if you have a reasonable doubt thereof, you may not consider whether the defendant failed to retreat in determining whether the defendant reasonably believed that the use of deadly force was necessary. When a person is attacked with unlawful deadly force, or he reasonably believes he is under attack or attempted attack with unlawful deadly force by one or more persons, and there is created in the mind of such a person a reasonable expectation or fear of death or serious bodily injury to himself at the hands of such attacker or attackers, then the law excuses or justifies such person in resorting to deadly force by any means at his command to the degree that he reasonably believes immediately necessary, viewed from his standpoint alone, to protect himself from such attack or attempted attack. It is not necessary that there be an actual attack or attempted attack, as such a person has a right to defend his life from apparent danger as fully and to the same extent as he would had the danger been real, provided that he acted upon a reasonable apprehension of danger, as it appeared to him from his standpoint at the time, and that he reasonably believed such deadly force was immediately necessary to protect himself against the attackers or attackers' use or attempted use of unlawful deadly force. In determining the existence of real or apparent danger, you should consider all the facts and circumstances and evidence before you, all the relevant facts and circumstances surrounding the use of force or deadly force, if any, the previous relationship existing between the defendant and the alleged injured party, or the other person or persons with the alleged injured party, together with all the relevant facts and circumstances going to show the condition of the mind of the defendant at the time of the alleged offense, including any and all threats previously communicated to the defendant from the alleged injured party or the other person or persons with the alleged injured party. In considering such circumstances, you should place yourselves in the defendant's position at the time and view them from his standpoint alone. Now, bearing in mind the foregoing definitions and instructions, if you believe from the evidence beyond a reasonable doubt that the defendant is guilty of murder as defined in this charge, but you further believe from the evidence, or have a reasonable doubt thereof, that the defendant reasonably believed that he was under attack or attempted attack with unlawful deadly force from Octavio Velasquez, and that the defendant reasonably believed, as viewed from his standpoint, that such deadly force as he used was immediately necessary to protect himself against such attack or attempted attack, and so believing he shot the deceased with a firearm, a deadly weapon, then you shall acquit the defendant and say by your verdict, not guilty. Indictment instruction. An indictment is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence of guilt, nor can it be considered by you in passing upon the question of guilt of the defendant. The fact that a person has been arrested, confined, indicted for, or otherwise charged with an offense does not give rise to any inference of guilt at his trial. Presumption of innocence instruction. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant, unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. Instruction regarding bias. You are instructed that jurors must be able and willing to make careful and impartial decisions that are not based on bias or prejudice. Do not let any personal bias, prejudice, sympathy, or resentment on your part, or any such personal emotion on your part, enter your deliberations or affect your verdict in this case. All persons deserve fair and equal justice under the law, regardless of their race, national origin, religion, age, ability, gender, sexual orientation, education, income level, or any other personal characteristic. You must set aside your own personal biases and prejudices during your deliberations and base your verdict on the evidence. Decisions based, either wholly or in part, on unfair stereotypes have no place in a criminal trial and will taint any verdict which is not based solely on the evidence and these instructions. Burden of proof instruction. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. The burden of proof in all criminal cases rests upon the state throughout the trial and never shifts to the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof exclude all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt, after considering all the evidence before you and these instructions, you will acquit him and say by your verdict, not guilty. Evidentiary instructions. You are instructed that if there is any evidence before you in this case regarding the defendant's having committed any offense other than the alleged offense against him in the indictment in this case, you cannot consider said evidence for any purpose unless you find and believe beyond a reasonable doubt that the defendant committed such other offenses, if any. Even then, you may only consider the same in determining the state of mind of the defendant, motive, opportunity, intent, preparation, plan, knowledge, identity, or absence of mistake, or accident of the defendant, if any, in connection with the offense alleged against him in the indictment. At times throughout the trial, the court has been called upon to pass on the question of whether or not certain offered evidence might be properly admitted. You are not to concern yourselves with the reasons for such rulings and are not to draw any inferences from them. Whether offered evidence is admissible is purely a question of law. In admitting evidence to which an objection is made, the court neither determines what weight to be given such evidence, nor passes on the credibility of the witness. As to any offered evidence that has been rejected by the court, you, of course, must not consider the same. As to any question in which an objection was sustained, you must not conjecture as to what the answer might have been, or as to the reason for the objection. You are instructed that you are not to allow yourselves to be influenced in any degree whatsoever by what you may think or surmise the opinion of the court to be. The court has no right by any word or any act to indicate any opinion respecting any matter of fact involved in this case, nor to indicate any desire respecting its outcome. The court has not intended to express any opinion upon any matter of fact in this case, and if you have observed anything which you have or may interpret as the court's opinion upon any matter of fact in this case, you must wholly disregard it. You are instructed that you may consider all relevant facts and circumstances surrounding the death, if any, and the previous relationship between the accused and the deceased, together with all the relevant facts and circumstances going to show the condition of the mind of the accused at the time of the offense, if any. Deliberations instructions. After you retire to the jury room, you should select one of your members as your presiding juror. It is his or her duty to preside at your deliberations, vote with you, and when you have unanimously agreed upon a verdict, to certify to your verdict by using the appropriate form attached hereto and signing the same as presiding juror. Your verdict must be unanimous and shall be arrived at by due deliberations and not by majority vote or any method of chance. It is only from the witness stand that the jury is permitted to receive evidence regarding the case, and no juror is permitted to communicate to any other juror anything he may have heard regarding the case from any source other than the witness stand. You are instructed that any statements of counsel made during the course of the trial or during argument not supported by the evidence, or statements of law made by counsel not in harmony with the law as stated to you by the court in these instructions, are to be wholly disregarded. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case, which is not shown by the evidence. If members of the jury disagree about a statement of any witness, the court reporter will read back to you certain testimony. The court will allow the court reporter to do this only if you submit a written request to the court, signed by the foreperson, that 1, states that the members of the jury have a disagreement about a specific statement of a witness. 2, identifies the witness who made the statement. And 3, requests this testimony be read back. The court will then have the court reporter read back only that part of the statement that the members of the jury disagree about. During your deliberations, you are also instructed that you must not communicate with or provide any information to anyone by any means about this case. You may not use any electronic device such as a telephone, cell phone, smartphone, iPhone, or computer to access the internet or any internet service, or any text or instant messaging services, or enter any internet chat room, post on a written or video blog, or post on any social media application such as Facebook, Snapchat, LinkedIn, YouTube, Instagram, TikTok, Truth Social, or X, which was Twitter, to communicate to anyone any information about this case or conduct any research about this case until the court accepts your verdict, if any. After you retire to consider your verdict, no one has any authority to communicate with you except the bailiff who has you in charge. You may communicate with the court in writing signed by the presiding juror through the bailiff who has you in charge. Do not attempt to talk to the bailiff, the attorneys, or the court concerning any question that you have. Your sole duty at this time is to determine the guilt or innocence of the defendant under the indictment in this case, and restrict your deliberations solely to the issue of the guilt or innocence of the defendant. If you have a verdict, or if you wish to have a break, turn on the red light and the bailiff will quickly respond. Signed by me, Nancy Mulder, presiding judge. The very last page are the 2 verdict forms, and they read, "We, the jury, unanimously find the defendant, Jordi Jose Estrada, guilty of murder as charged in the indictment." Or, "We, the jury, unanimously find the defendant, Jordi Jose Estrada, not guilty." There's a place under each of these verdicts for the presiding juror to sign and then print his or her name. We will now have arguments of counsel. Mr. Worley, you may open.
Thank you, Judge. Good afternoon, ladies and gentlemen of the jury. I appreciate your attention this week. When I talked to you a few days ago during jury selection, we talked a lot about what the state was going to be required to prove. We talked about the elements of the case. We're going to go back over those here in a minute. And we talked about the burdens of proof. That's really kind of the main things that we talked about, right? We talked about the actual elements that we have to prove, along with how we had to prove it, by what level of proof, right? Beyond a reasonable doubt, that's what we're saying. And that's the standard that we have, and that's the standard that we expect you to follow. And we have proved to you beyond a reasonable doubt that Jordi Estrada committed this murder. So the verdict that we are entitled to is guilty. Well, let's talk a little bit about it. Now, you just heard a very long jury charge, okay? And you're gonna get a copy of this to take back so you can read it for yourselves and you can look over it, all right? There are a few things that I would like to, go through here. We talked about the mental state definitions the other day, right? We talked about the person acts intentionally or with intent with respect to the result of his conduct when it is his conscious objective or desire to cause the result. Or knowingly, a person acts knowingly or with knowledge with respect to his result of his conduct when he is aware that his conduct is reasonably certain to cause the result. Take out a firearm and you fire it at a person, and you have, even if you try and say you didn't intend to kill them, you have the knowledge that firing a firearm at another human being is reasonably certain to cause the result of their death. So that's intentionally and knowingly. Now, you're going to see this paragraph on voluntary conduct, right? That's going to ask you whether or not this is an accident. You have to determine whether or not you believe the testimony of the defendant that this was an accident. Now, this is an interesting case, right? Because we have a defendant who's attempting to, like I said, ride two horses at the same time. He's trying to say, well, it was an accident, but it was also self-defense. You can't have both. You can't accidentally use self-defense. You either intentionally use self-defense or it was an accident. It's one of the two. If you determine that this was all just an accident, that he didn't mean to do anything, that gun just went off, then that's a not guilty, right? Now that goes against all the evidence that you saw, all the evidence that you heard. But if you believe it's an accident, then it's just an accident, and that's a not guilty. But we believe. Just turn off.
It went to restart. You want me to touch it to start again? It said system shutting down, and then it went back to the touch to start.
Can I have a moment, Judge?
You may.
There we go. Okay. These are the elements that we had to prove. These are the elements that we did prove to you. That the defendant, Jordy Estrada, on or about a certain date, in this case January 23rd, 2022, in Dallas County, Texas, that he did intentionally or knowingly cause the death of an individual, that's Octavio Velasquez, and that he used or exhibited a deadly weapon, which in this case was a firearm. The other way that we can prove that is that he intended to cause serious bodily injury, and he committed an act clearly dangerous to human life that caused the death of Octavio Velasquez. And that act that would be clearly dangerous to human life would be shooting Octavio with a firearm, okay? But I want to focus on just the regular version here, where it says that the defendant intentionally or knowingly caused the death of an individual. Now, I went through all those elements with the defendant when he was on the stand. And he indicated that yes, he was the person who shot Octavio Velasquez on January 22nd, or 23rd rather, 2022, and that he caused the death of Octavio Velasquez. And I asked him if he intentionally or knowingly did that. And at first he said no, and well then he said yes, he did do that. And then he said, well, yes, I did do that. And then he said, no, I didn't do that. He was getting confused by his own story, and I can't blame him. But the fact is, you know what happened. You know what happened that day. You know it wasn't the story that he told you happened, okay? None of this stuff happens in a vacuum, right? When we talk about that, what we have to prove the case by, beyond a reasonable doubt, how do we do that? You know, I think probably what Mr. Howard's going to tell you is, and as we we go through the charge, it'll talk about that we have to exclude all reasonable doubt. And we don't have to prove it beyond all possible doubt, but then we have to exclude all reasonable doubt. Well, how do we do that? How do we do that? Does that mean that we have to provide specific evidence to disprove every single theory that the defense might come up with? No, it doesn't mean that. It means that we have to prove these elements beyond a reasonable doubt. If you believe these elements beyond a reasonable doubt, then by that very nature, that means that we've excluded anything else. If this is the only reasonable way that this could have happened, then anything else can't be reasonable. Does that make sense? And in this particular case, we can tell from the physical evidence and from the testimony of Jocelyn Rodriguez that there's only one way that this could have happened. By the testimony of the medical examiner, there's only one way that this could have happened. And look, Mr. Estrada didn't have to testify, okay? He could have just had his attorney, come up with these theories and ask questions about them, and he might have even still got some of these things in the charge. But he did take the stand, and you can hold him to the things that he said. You can hold him to his version of the facts, and you can say, is that version of what he said, not some other version that Mr. Howard wishes that it was, but not some other version that maybe we could concoct, but is the version that he said, is that reasonable? And it's not. It's not just unreasonable, folks, it's impossible. His version of what happened that day is not possible. And you know it's not possible by the physical evidence that you saw in this case. It is not possible that he fired that gun laying on the ground with Octavio Velasquez over top of him, and that bullet then struck Octavio Velasquez in the back of the shoulder and went into the back of his head. It is simply not possible. It does not fit with the physical evidence that we know is true. Because in every case, I mean, what if Jocelyn wouldn't have been there? If Jocelyn hadn't been there, then we would only have that physical evidence to go by, right? And there are plenty of murder cases where you don't actually have a witness to what happened. Because Jocelyn was there, we know that Jordy Estrada came out of that house that morning. And we know there was just the three of them there. We know that Jordy was the only person who was available to be the shooter of Octavio Velasquez. And so that limited kind of what he could say happened. He had to have some kind of way to make this not his responsibility, right? And so it's hard to say self-defense when you shoot somebody in the back. When you shoot somebody in the back of the head, right? And so he went with accident. But again, the story that he concocted, the lies that he told you up here, and look, let's just call it what it is. He lied to you. He lied to you just like he lied to the police, just like he lied to that 911 operator, as he tearfully lied to that on that 911 call. He lied to them and he lied to you. And this is not just me saying this. You know that that's the case based upon the physical evidence, based upon the other evidence that we have, that we know is true. We know where Octavio Velasquez's body was. We know that from the medical examiner's testimony that once that bullet entered his brain, he wasn't making any more movements. He wasn't getting shot and then turning around and taking a couple of steps and staggering and falling. No, he was dead right there. He was dead before he hit the ground. When he hit the ground, he never moved again. And so that left us with a static crime scene. And that left us with certain things that any explanation for what happened had to fit in. He had to have been shot from behind. He had to have been shot from a certain angle in order to make those wounds, and in order for that bullet to have the trajectory that it had when it passed through his body. And the shooter had to be in a certain position, or a certain location. And Jordy Estrada's version of how that happened simply does not fit with those facts. Now, On the subject of self-defense, there are a few things that it talks about in here. Use of force is not justified in response to verbal provocation alone, or if the defendant provoked the other's use or attempted use of unlawful force. Now, all the evidence points to the fact that Octavio was running away at the time, or at least turned away, maybe fell, but he was going away at the time that he was shot. And that's the time that we're talking about, right? When that trigger was pulled and when that gun was fired, we know that Octavio had his back turned to that firearm. So he did not present an immediate threat. It was not reasonably necessary to use a firearm against him at that time. But who came out with the gun in the first place? Octavio didn't have a gun. We know he didn't have a gun because, again, he died right there. If he'd had a gun and still been on his person, he didn't have a gun. But who did have a gun? Jordy had a gun. So even under Jordy's scenario, right? Even under his incredible, unbelievable statement, he's saying that he came outside angry, pulled a gun, and Octavio charged at him. Well, he might well, under those circumstances, have been justified in doing so, right? He didn't have a gun. Jordy's the one who's coming out to threaten him with a gun. But again, we know that's not what happened. And it says that he must be protecting himself against the other's use or attempted use of unlawful deadly force, or to prevent another's imminent commission of aggravated kidnapping, murder, sexual assault, aggravated sexual assault, robbery, or aggravated robbery. And what Mr. Howard is going to tell you, and what Jordy was trying to get at up there, was that he was afraid that Octavio was going to murder him. And so therefore he's justified in killing Octavio. That's the only way that works. That's the only way you get self-defense, okay? Now, but we don't believe, there's no evidence of any kidnapping, sex assault, robbery, aggravated robbery, anything like that. The only way that he gets that self-defense is if you believe that he believed and reasonably believed that Octavio was about to murder him. So let's talk about the reasonableness of that belief.
You've used 12 minutes.
Thank you, Judge. Let's talk about the reasonableness of that belief. Here is a person that he told you, that Jordy told you, he had never had any fear of in his life. That they have been like brothers since they were 7 years old, since he was 7 years old. This is a person that he has in his home at every opportunity. This is a person who is the godfather of his son. It's not somebody who he feared. It's not somebody who he had ever had an opportunity to fear. It's not someone who had beat him up. It's not somebody who had threatened him. The only threats that you heard about were the threats that came from Jordy to Octavio at that party. But what Jordy wants you to believe is that it just so happens that on the morning that he gets so enraged, that he gets so super angry, as he called it, at both Octavio and Jocelyn, that he kicks her out of the house, that he throws the clothes at, says, "Get your stuff and get out," to the mother of his children. That on the morning that he gets so angry that once he's kicked her out of the house, he goes to the closet and he grabs his gun. And then he goes outside to confront Jocelyn and maybe Octavio. I don't know if he knew Octavio was still out there, but I know he knew Jocelyn was out there. It just so happens that that's the day, that that's the moment when he's angry, when he's got his gun, when he's ready to go out there and confront them for what he says is cheating. After he's told Jocelyn what he'll do if she ever cheats on him. that that's just coincidentally the first time in his life when he fears Octavio Velasquez. When he's angry, when he's got the gun. Why would Octavio have any reason to want to harm Jordy in that moment? As far as he knows, everything's fine. This isn't the first time this has happened. He's happy, right? Everything went how he thought it was going to go that morning. He's good. And it wasn't the first time. So why in the world would he be a threat to Jordy? There was only one threat out there that morning, and that was Jordy Estrada. He was a threat because he was angry. He was a threat because he felt threatened, not by Octavio physically, but he felt threatened by Octavio as a man. Because he felt like Octavio was taking what was his. He was taking his wife, not taking his life. And you can consider, it's one of the things that you'll see here too, is that it talks about this in determining the existence of real or apparent danger. You should consider all the facts and circumstances and evidence before you. All relevant facts and circumstances surrounding the use of force or deadly force, if any. The previous relationship existing between the defendant and the alleged injured party, or the other person or persons with the alleged injured party. Together with all relevant facts and circumstances going to show the condition of the mind of the defendant at the time of the alleged offense, including any and all threats previously communicated to the defendant, which there were none, from the alleged injured party. And that's from Jordy. There were never any threats made by Octavio to him. Or the other person or persons with the alleged injured party. In considering such circumstances, you should place yourself in the defendant's position at that time and view them from his standpoint alone. And from Jordy's standpoint, he was angry, he was hurt, he was insecure, and he had a gun. And why did he have that gun? He didn't bring that gun out there for no purpose. He wasn't going to go cool off by firing a few rounds at the range. He came out with that gun to do something with it. And he did it. Like I said, none of this happens in a vacuum. Folks, based on the facts, the incontrovertible facts, the physical evidence, there is only one reasonable verdict that you can come to. It doesn't matter what other fantasies the defense wants to talk about. There is only one verdict that is supported by both the facts and the law. And that verdict is guilty. Thank you.
Thank you, Mr. Mulder. Mr. Howard.
Yes, Your Honor. May I have a minute to switch the technology and get set up?
You may.
Thank you, Your Honor.
Mm-hmm.
Ladies and gentlemen of the jury, there is one question that's going to be before you in this case. And that is, did the prosecution rule out every logically possible reasonable doubt? Now, I too would like to go over some of the instructions that you received. I'm going to start with the presumption of innocence. All persons, here on page 8, like you've heard, you're going to be able to take these back with you because I know they're long and they're wordy, but these will really help with your deliberations. presumed innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. Now, we've talked about this over and over and over again because it's so important. We talked back in jury selection about how a criminal trial is not weighing which side do I believe. A criminal trial is not do I think he did it or do I think he meant it. Okay? A criminal trial is has the government ruled out every logically possible reasonable doubt. We start with this presumption of innocence. You are instructed, the law requires, and this is why the judge said in the beginning, jury service isn't easy. It's not meant to be easy. You have to start off doing something that is very difficult to do. It's not human nature. The judge said in the very beginning, it's totally natural to come into jury service and say, wonder what he did to get himself here, right? But the law asks you to do a very difficult thing that all 12, all 13 of you promised the judge and both sides you could and would do, that you would follow the law and presume innocence, and only move beyond that if the government can rule out every logically possible reasonable doubt. Next, the presumption of innocence alone is sufficient to acquit the defendant, unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. This is so important we keep saying it, right? The presumption of innocence, you start there and you finish there unless the government's evidence moves you off of it. And how does it do that? There's only one way, and that's that one question we started with. Has the government ruled out every logically possible reasonable doubt? If they haven't, the presumption of innocence alone is sufficient to acquit the defendant. Next, we have the burden of proof. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element charged beyond a reasonable doubt. We'll stop there. This is so important we say it over and over and over again, because the law understands that the job we're putting in front of you is not natural. It's not the way regular people think. But because of what's at stake for the Velasquez family, for Jordi Estrada and his family, for our community to get this right, we keep telling you how high this burden is. And then continue reading, and if it fails to do so, you must acquit the defendant. The burden is not on us. It also says in here that the burden never shifts to the defense. In the event you have a reasonable doubt as the defendant's guilt, after considering all the evidence before you in these instructions, you will acquit him and say by your verdict, not guilty. I know this is repetitive. It's supposed to be because of how important it is. Now, if we lived in a world where all the government had to do was charge us with a crime, accuse us of a crime, and that alone was enough to make us guilty, the world would look like this. This domino would lead right to this domino, and guilty. We don't live in that world. The reality is, the charge, as you've heard, as the judge told you in jury selection, as the judge just read to you, and as you can read again, the charge, the indictment, is no evidence of guilt whatsoever. The presumption of innocence alone is sufficient to acquit the defendant because the charge is no evidence whatsoever. The only way they get to guilty is if they can rule out every logically possible reasonable doubt, knock down every domino in a row to get to their guilty. If they can't, they don't get to guilty. Okay? So, let's talk about some of these logically possible reasonable doubts. The government must rule out the logically possible reasonable doubt that maybe Jordy did cause Octavio's death, but he did so involuntarily. If the government cannot rule that out, if the government cannot rule out the logically possible reasonable doubt beyond all reasonable doubt, they don't get this domino, and that charge will never hit that guilty. It's not possible. So, let's talk about the law on voluntary. You are instructed that a person commits an offense only if he voluntarily engages in conduct, including an act, omission, or possession. Conduct is not rendered involuntarily merely because the person did not intend the results of his conduct. We talked about it in the beginning, and guys, you know this. If a doctor hits my knee and it causes an involuntary spasm, muscle contraction that kicks that doctor, I didn't commit the crime of assault even if that caused him injury, right? Because I didn't voluntarily engage in that conduct. Therefore, if you believe from the evidence, beyond a reasonable doubt, that on the occasion in question, the defendant, Jordy Jose Estrada, did cause the death of Octavio Velasquez by shooting the deceased with a firearm, a deadly weapon, as alleged in the indictment, but you further believe from the evidence, and this is important, or have a reasonable doubt thereof, that the death was the result of an accident and not the voluntary act or conduct of the defendant, you will acquit the defendant and say by your verdict, not guilty. That's a mouthful, I know. What we're saying is, if you believe the government has proven to you beyond all reasonable doubt that Jordy caused Octavio's death, he shot him with a gun, and that caused his death. But either you believe Jordy, or, and this is where I disagree with Mr. Worley, it's not up to you believing Jordy. You don't have to believe, it's not a do I believe the prosecution or do I believe the defense. That's why we started off with the law and went over it over and over and over again. It's not a contest of who convinced me. If you have any reasonable doubt, any logically possible reasonable doubt, if you're not willing to reach in to the government's Tylenol bottle and pick out that possible poison pill, if that's a reasonable doubt to you, that's enough. Even if you're thinking, you know what, I don't know that I believe that. It is there any logically possible reasonable doubt left in my mind? Now, let's talk about the evidence that can lead you to the question of voluntariness. You heard from former FBI Special Agent and Firearms Instructor Santiago Mulder. He talked to you about, frankly, things that I know you know, that sometimes we react involuntarily. But he put the science and the technical know-how and the experience behind what we know in our hearts, right? That if I get startled because someone jumps out from behind the corner and I go, ha! And when I do that, I accidentally elbow my wife, that I didn't voluntarily attack her, right? Even if it did cause her some injury. That if I lose my balance and I squeeze my hand because of an involuntary reaction, something I can't control whatsoever, Gesundheit, and I squeeze a trigger or break the cup in my hand or whatever it is that happens because of that involuntary reaction, Gesundheit, it's contagious. then I'm not legally responsible for that. And you heard about the sympathetic response, something we know, that if I am struggling with someone, my body can contract. And if I'm holding a gun, something terrible could happen. A tragedy could happen. Now the government wants you to believe that the only way this could have possibly happened, the only way, is that Octavio hears Jordy racking a gun, or some other thing makes him run away, okay? So the only way is he has to be running away. That's what Detective Sarah said to you. That's what Mr. Duplanis said in opening. It's what Mr. Worley said to you in close. That's the only reasonable explanation, is what they keep saying. So Octavio has to be running away in the most profoundly unnatural way for a human being to run. They want to say that he could have been ducking or this or that. If I duck or zig or zag, look at the line of my body. In order for me to get shot in the way Octavio did, that gun would have to be down there. So I'm running this way. It doesn't make any sense whatsoever. Not to mention the fact that their own witness, Jocelyn Rodriguez, comes back and says, I didn't hear the unmistakable sound of the racking of a gun, something that everyone recognizes as chilling. So if Jordy racked that gun, which is what the state believes so much from finding this bullet that looks totally different, it's a different casing type, steel as the crime scene, their own witness said, versus brass, the other one. They're different colors, they're different makes, they're different manufacturers, yet the only reasonable explanation for how that could have appeared there is that Jordy must have racked it. Okay, well if that's the case, Jocelyn would have clearly heard the sound, the unmistakable sound of racking of a gun. How do we know that? Because she's told us repeatedly she was at the corner or just past the corner of the building. That, you can see it in the pictures, you take them back to look at them if you have questions. That's 15 feet, 20 feet, 25 feet. It is a few steps away, guys. That takes a few steps when you're running. So that means if, as Detective Sarah told you, the rack would have had to have happened before the first gunshot, because you're racking the gun to make the threat, the unmistakable sound, and that discharges the live round that's in the chamber, right? So that happened before the gunshot that she clearly heard from just a few feet away. So that means the rack happened even closer, when she's even closer and can hear it unmistakably. As their witnesses said, it is an unmistakable sound. And yet, she came back and she testified. She never told them, she never told Detective Sarah in her multiple interviews that she heard the sound of racking. And then she told you, I never heard the sound of a racking. And I even made the sound. Nope, didn't hear that. So, again, the government wants you to believe that the only way it could possibly happen is that way, their way, the running away and the unnatural method. But if Octavio comes forward, which Jocelyn corroborates, the last thing she saw is Jordy and Octavio moving towards each other, exchanging words. Okay? That's their witness. That's their evidence. The last thing she sees is them moving towards each other. They start off, we estimated, 8 feet, 10 feet from the door to the wheel well of the car. Now they're moving towards each other. Everybody agreed they're not moving slow. They're moving towards each other at a regular pace. Doesn't take long to close 10 feet, let's say, if two people are both moving. Okay? So, in that time, if Octavio makes physical contact with Jordy, whether he intended it as an attack or not, if that knocks Jordy down, we have the loss of balance. If Jordy hits the ground, we have the startle. The fact that his best friend has just knocked him off his feet is in and of itself startling. But the ground hitting is another story. And if they tussle at all, that's the sympathetic. That's what Mr. Moya meant by the evidence. I hear the possibility of all three reasons for involuntary discharge. So then, if Jordy falls down, he is at exactly the angle of that bullet. As much as Mr. Worley wants to believe that Jordy must have been firing straight up, and therefore he would have hit the buttock or the shoulder blade, that's not how someone falls when they get hit. If I get hit, I'm at least, if I don't take a step back, I'm at least going to go backwards. And if I'm 5'6", like Jordy, I'm going to go back 3 feet to where the gun might be. That creates the angle. So if Octavio hits him with his left shoulder or his left arm or pushes and then turns just in the slightest way, the time it would take Jordy to hit the ground is exactly the time it would take for him to turn. And that angle matches entry, exit, entry. That is, I would submit to you, a logical possibility that the government can't rule out because no one saw it. Jordy also explained to you that he thinks the gun went off when he hit the ground, but he repeatedly said, it all happened so fast, it was a blur. I can't remember the nanosecond by nanosecond breakdown for you. Is it possible that as they struggle and Octavio is leaning into him, if I'm here, Jordy is right-handed, that would put his gun right there. If that gun is there, it matches exactly the same angle. I don't know how Octavio ended up shot. Frankly, either does the government, or the detectives, or do you. The unfortunate reality of the situation, the tragedy of the situation, is that there is not enough evidence to rule out any logically possible reasonable doubt about exactly what happened. We're never going to know. There's a reason I put on that easel the very first day of opening statement, maybe we'll never know, because no one was there. No witness, not even Jocelyn, the only witness who was out there, can tell you what happened. And in either scenario that I presented to you as possible, both their medical examiner and Detective Sarah agreed that both the struggle could affect the way Octavio's body fell, as well as the impact of the bullet. And medical examiner, Dr. Lenfest, told you there is no reliable way to predict the way a body will fall when all of a sudden their brainstem is cut and they instantaneously die. He's not going to take a step, he's not going to do anything, and I can't tell you how he's going to fall. I asked him, can you rule out the possibility that the bullet came from underneath, from the ground, with Octavio over him? He said, nope, I cannot rule that out as a possibility. That's their expert, cannot rule that out. Is it possible that he then falls on his face in exactly the same way that the government thinks it happened, but not because he's running away in this crazy way, but because he got hit by the involuntary gunshot and falls and hits his face and causes the damage we saw? Can you rule that possibility out? Nope.
You've used 20 minutes.
Thank you, Judge. So, the government must rule out the logical possibility that maybe Jordy involuntarily caused his best friend's death. If they can't rule it out, if there's even the tiniest bit of doubt left that you find reasonable, they don't get this domino, and that will never hit charge. That will never hit guilty. Let's talk about another logically possible reasonable doubt. The government must rule out the logical possibility that maybe Jordy was defending himself. Now, with all due respect to Mr. Worley and his statement that Jordy doesn't get to ride both horses at once. That's not the way the law works. Especially in a moment where Jordy repeatedly told you it all happened so fast, I don't know exactly how it happened, I'm doing the best I can to tell you what I remember and how it happened in a stressful, adrenaline-filled, chaotic, scary time. I wasn't planning for this, I didn't take notes. I've been up all night. And so, if you believe that it all happened so fast that even Jordy can't reliably tell us exactly what happened, it's up to you to determine whether there's a logical possibility that even Jordy can't fully understand what happened. So I ask you, has the government ruled out the logical possibility that maybe Jordy reasonably believed that his life was in danger and that he immediately needed to use deadly force to protect himself against the use or attempted use of deadly force? So let's talk about that and the law. A person is justified in using deadly force against another if he would be justified in using force against the other in the first place, as set out above, when he reasonably believes that such deadly force is immediately necessary to protect himself against the other's use or attempted use of unlawful deadly force. And I do agree with Mr. Worley. I'm not going to go through the various crimes that could have been committed because there's no evidence of that, and there's no reason to even believe that. Nothing we've heard even raises that possibility, so I'm not even addressing that. What I'm addressing is whether in that moment, without his contacts in, with his vision blurry, his best friend acting in a way that he did not recognize as the Tabito I know, who's high on cocaine and intoxicated on alcohol, and Dr. Lindfest tells us that the multiplying effect of those two things intensifies and prolongs the effects of cocaine, which in and of themselves, everyone agrees, can cause aggression and paranoia and violence. If in that moment, without his glasses on, not able to see well, scared, frustrated, angry, all of it, when Octavio starts to move towards him and he sees the figure in front of him moving towards his waistband, if that, in that moment, in those shoes, in that split second of chaos, if it would be reasonable to think, oh my God, the person I know who has a gun, who carries a gun there, could be going for a gun. You don't have time to think about it, and you don't get to make that decision in this comfortable, calm courtroom after the fact. The law tells you, the judge tells you, it is not necessary that there be an actual attack or attempted attack. Again, you don't have to believe Jordy, and Jordy doesn't have to be right. The law says a person has a right to defend his life from apparent danger as fully and to the same extent as had the danger been real. That's because we don't decide self-defense in a vacuum after the fact with 20/20 hindsight on, with our contacts in, so to say. We have to decide it in the moment, in the shoes of the defendant, in that chaos, in that fear. Everyone says it happened so fast. And that's what this means. So the law recognizes that. And it says, provided that he acted upon a reasonable apprehension of danger as it appeared to him from his standpoint at the time. We have to place ourselves in Jordy's shoes and decide it based on what he's seeing, what he's feeling in that moment. That's okay. And that he reasonably believed that such deadly force was immediately necessary to protect himself against the attackers or attackers. There's not multiple attackers. of attempted or unlawful deadly force. And you should place yourself in the defendant's position at the time and view it from his standpoint alone. Okay? So, in that chaotic moment with your best friend acting in a way that you've not seen before except when he's on cocaine and alcohol, when he comes at you after you tell them not to come 11 times, which Jordy told you that Tabito I knew would never have done that. But this is different. He came, he was high and drunk, and even though Jordy ended up being wrong, there's no evidence that Octavio did have a gun. But he made a motion for the part of his body where he carried a gun before, and Jordy reacted in a split second in the chaos. So if the government cannot rule out the logically possible reasonable doubt that in that moment, in that chaos, that fear was reasonable, then they don't get this reasonable doubt either, and they can't get to the guilty. That get the guilty away because they're nowhere near it. The prosecution must rule out the logically possible reasonable doubt that maybe Jordy caused the death of Octavio, but that he lacked the necessary mental state. So let's talk about the law on this. A person acts intentionally, this is on page 2 of your charge, or with intent with respect to a result of his conduct when it is his conscious, objective, or desire to cause the result. That's why I kept asking those questions. Because intent, what does intent mean? I'm a lawyer, I know the definition, but when we talk about conscious, objective, or desire, you have to ask yourself, do you believe that it was Jordy's conscious, objective, or desire to kill his best friend, his brother, since childhood, the godfather of his son Aiden, the planned godfather of his son, of his daughter Anaï? And then a person acts knowingly, also on page 2, or with knowledge with respect to a result of his conduct when he is aware of his conduct, is reasonably certain to cause the result. Again, I asked him, in that moment, did you even have time to become aware? No. And you can ask yourself, forget what you believe or don't believe about Jordy and what he's told you. Just ask yourself if you think this person knowingly killed their best friend. And beyond that, you can look at any evidence and how it moves you and whether you think it raises that logically possible, reasonable doubt. Ask yourself about Jordy's reaction after the fact. The uncontroverted evidence that Jocelyn told you that he called her wanting to commit suicide, that Detective Billings confirmed by putting him in suicide watch, that Jocelyn told you that he was crying hysterically on the phone and when he got home. He wasn't thinking clearly. He kept saying he wanted to kill himself. He told her he was about to blow his brains out. And she talked him down. And he threw the gun away because he told you, I knew that there was a chance that I would do the thing that I was afraid I was going to do, and I was trying to stay for my kids. Could he have coldly and calculatedly thrown that gun away in an attempt to subvert an investigation? Yeah, he could have. He also could have done it simply because he wanted to kill himself, as Jocelyn and Detective Billings have confirmed. And as you heard, his reaction in front of Detective Billings, something that I pointed out because it was so unique, I've never seen it before. A detective reaching out to a suspect in an interrogation room to say it's okay, and then Jordy puts his hand, and Detective Billings puts his other hand on top of Jordy, and Jordy rests his head on Detective Billings' arm and starts sobbing. And Detective Billings puts his arms around him and holds him. Ladies and gentlemen, that in and of itself may raise the reasonable doubt to you. Did that person have the conscious objective or the awareness government can't rule out the logically possible reasonable doubt that maybe Jordy didn't have the necessary mental state. They don't get this reasonable doubt, and they can't get to their guilty. And finally, I told you in the beginning, maybe we'll never know, and that you could think of other logically possible reasonable doubts as they occur to you. You don't have to take my word for it or their word for it or anybody's word for it. It's up to you because you all have your own definition of reasonable. So you have to ask yourself about the maybe we'll never know. The only witness Detective Sarah, Detective Billings could find that was even out there was Jocelyn. And what did Jocelyn tell them repeatedly and you? That she didn't see it, that she ran away because she was triggered by her upbringing and her suffering through violence at home. So she ran, and that all she knows, she didn't even see a gun. She saw Jordy's face at the door and thought, oh no, and ran. And all she heard was a gunshot. And yeah, she thought in that moment the gunshot could be for her. Of course she did. So she ran. But she told you she can't rule out any of these doubts for you either, because she told you, I didn't see what they were doing just before or when the gun went off. The last thing she saw was them moving together, exchanging words. She can't remember exactly what they said because she's running by in a blur. And then she hears a gunshot. She doesn't know if Jordy is the aggressor or Octavio is the aggressor because the last thing she saw was them moving together. And so no one can tell us what exactly happened. As much as the government wants to tell you that the only way is this running away thing, Dr. Lindfest tells you there's no way to determine. There's no way to determine the path of the bullet. I can only say the trajectory as it went through the human body. There's no reliable witness at all that can tell it. And that's not, I'm not saying that people are bad. This is a tragedy. But to underline that tragedy and convict someone when we really don't know what happened is not what the law intends. So, if the government can't rule out the logically possible reasonable doubt that maybe you'll never know, and that leaves you with a doubt that is reasonable to you, then they can't get this and they can't get to guilty. And at that point, all we're left with is a charge and a bunch of doubt, ladies and gentlemen. You see, they have to have, every one of these, let me put them back. They have to have, the charge tells you that he must have acted voluntarily, and not that you believe he acted involuntarily, right? But that there's any logically possible reasonable doubt that maybe he didn't. That only stays if there's not a single doubt that's reasonable in your mind. They have to rule out the logically possible reasonable doubt of self-defense. Not that you believe he was defending himself, not that you believe that it was reasonable in that moment, but is there a possibility in reason, in your mind, that in that second he could have thought his life was in danger and that that action was immediately necessary to defend himself? If they can't rule that out, they don't get it. And then mental state. And then others. And you see, the thing about our system is they need every single one to get to guilty. If one of them is not there, that doesn't go to there. If two of them, three, if all of them are gone, they don't get to there. The only way they get it is if every single one of these stays. And ladies and gentlemen, I don't believe they can rule out any of these doubts to you. I think the evidence has established that, not beyond all reasonable doubt. And if they can't, they don't get their guilty verdict. What what we're left with is two possibilities. One, guilty. We talked about this in the beginning. Has the government ruled out every logically possible reasonable doubt? It's not a photo finish. It can't be a close call, right? It is beyond.
I reject that as a misstatement of the law. There's nothing that indicates that it just beyond a reasonable doubt, whether it's close or not. As long as it's beyond a reasonable doubt, they can convict.
Sustained, the jury will have the law in the court's charge.
I've been over the law, he's been over the law, you'll be able to read the law. If there is a single doubt in your mind that is reasonable, no matter how small it is or big it is, because you and you alone are the ones who decide what is reasonable. So if that 1 in 1,000 or 1 in a million chance, like we talked about with the poisonings and Tylenol, if that is reasonable to you because of what is on the line, that is reasonable to you, and no one can tell you otherwise. So, has the government ruled out every logically possible reasonable doubt? They either have or they haven't, because not convinced is not guilty. We don't get photo finishes in criminal courtrooms. It's not, I think he did it, he might have done it, he probably did it. That's not the law. To decide a case based on that would be to violate the law and to violate your oaths, okay? There is one question and one question only. We started with it, and we're going to finish with it because this is why, this is the freedom that protects each and every one of us and everyone we know and love. Has the government ruled out every logically possible reasonable doubt? If they haven't, then your verdict is not guilty. Whether it is because of voluntariness or reasonable doubt or mental state or something else that you find to be a reasonable doubt, you go to the bottom of the page and find him not guilty. Even if you believe beyond all reasonable doubt that he caused the death and did so intentionally or knowingly, if you think that was the product of an involuntary muscle contraction, the way Santiago Moya explained, if that is even reasonably possible in your mind, you come here. If you think it was reasonable in that chaotic moment that he felt it was immediately necessary to defend himself, and he thought that his best friend, who was not the person he knew in that moment because he was high on cocaine and he didn't have his glasses so he couldn't tell for sure what was happening, if that apparent threat, as the judge explained to you, was reasonable in that moment to move him to making a tragic mistake, but that he doesn't get to look backwards to, and we don't either, if that was reasonable in that chaotic second, then you come to this. Okay? So, thank you for your attention. The government deserves a fair trial. Jordi Estrada does. Both families do. And I appreciate your attention and to all of this. Thank you.
Thank you, Mr. Howard. Plantis, you have 22 minutes.
Thank you. Just want to clear up some logistics. I'm not the government. My name is Stephen Plantis. I represent the people. I represent you. And another thing is that I don't know what logically possible reasonable doubt is. It's not in any statute, it's not in the case book, any cases. It just doesn't exist. It's kind of made up. And in that regard, I got to say, the defense has done an excellent job of attempting to stretch the boundaries of reasonableness to the point where no one's guilty of anything. That's money well spent, I'll tell you what. But this case is about this guy. This guy who was everybody's friend, who was happy-go-lucky, who we've never heard has raised a hand in anger to any single human being. Everyone described him the exact same way. You have no evidence whatsoever this guy had any reason to fear him, any reason to do anything but love him to death. Well, now we got to drag him through the mud to make sure that Jordy doesn't suffer any consequences. It's hard to know where to start, but one thing I am glad to be able to tell you is that I'm the last lawyer you're going to have to listen to today. And I'm going to tell you one other thing, I'm going to keep it short, because I think Mr. Worley did a fantastic job of explaining everything to you and letting you be confident that the burden of reasonable doubt has been reached. But the defense has raised some issues that I feel must be addressed. First of all, on the issue of self-defense, can we all agree that someone that's shot in the back has not been shot in self-defense? And the defense counsel has got up here and said, oh, we had to contort your body. The only thing that makes sense is that when Tabito realized that Jordy was going to shoot him, he turned around and ducked. And that's why the bullet went at an odd angle. He was ducking because he knew, just like Jocelyn was running zigzag. Same reason. She was expecting a gun to come, a gunshot to come. Tabito said, "O.S." and turned and ducked. And it didn't do any good. The defense counsel said that the coroner stated that he couldn't rule out that Jordy was on the ground shooting. But he said it was highly unlikely. He said that while he couldn't rule it out completely, that he would have had to have been standing directly over him. And none of that would explain how the bullet got in his back. So, as far as the other two, voluntariness and whether it was intentional, which to me it kind of sounded like the same thing, right? It's like, I did it, but I didn't mean to do it. I mean, it's escaping responsibility. It's an excuse, is what it is. And we know that Jordy does not like to accept responsibility for a whole lot of things. There's always someone else to blame for something that he's done. I mean, the reason he owns a gun is because, well, my friends own guns. They don't want to own a gun. The reason he sells cocaine, well, all my friends sell cocaine. So that's why. Why did I shoot Tabito? Because Tabito was drunk and high. It's always someone else's fault. And he's very good at it. Because he looks like he's 12. He looks like a kid. But behind those eyes are a cold, possessive, dangerous human being. And everybody knows that, except for Tabito on that night. The mistake he made was sleeping with a dangerous coke dealer's girlfriend and getting confronted by the dangerous person. But he had no way of knowing that this was unacceptable. The text he got was, "Come." And so he got excited and he was going to come. But regardless, even if you say, oh, well, he should have listened to Tommy, he should have listened to Jordy, and he should have. But at the same time, nothing he did caused him to deserve to be shot in the back. None of that. Now, what evidence do we have that Jordy did not voluntarily shoot that gun, or didn't intend to shoot his friend? What evidence do we have? We don't have any evidence of that at all. So we have to kind of like pull that out of whole cloth. What evidence do we have that Jordy did intend to do it? Well, then we have plenty. We really do. And the defense counsel said, we can't listen to what Jordy has to say because Jordy's confused. Either I meant to shoot him, but he was in self-defense, or I didn't mean to shoot him. I'm not sure which. You know, but we don't want to know what Jordy has to say. He's a liar. Jordy has lied to every single person he's ever talked to about this case. Why would we, right now, where he's got the most to lose, where his back is up against the wall, the motivation to lie is as strong as it, or stronger than it's ever been. Why would we listen to what he's got to say about what happened to this day? He can't tell the truth about this, and frankly, I think he came as close as he can to telling the truth when he sat here and said, yes, I shot my friend. That was the furthest we could bring him along to the truth and accepting responsibility. We all know what happened. A possessive, jealous, dangerous guy who had been up all night long. Let me just say, I've been shocked that in interviewing all these people and talking about the events that make up this case, every single one of them says, oh, I don't do cocaine. Every one of them. Not a damn one. Tabitha was the only one in this whole crew that did cocaine. They all just went to the bathroom together to hang out. They were able to stay up all night long. I've never been able to do that, not even when I was 18, and that was a long time. But, yeah, he's been up all night long. He's drunk and he's high too. We know that. And he's red hot mad. He's killing that. And he gets that gun. And at this point, Tabito's left. I mean, he told Tabito to leave. Tabito said, okay. We have no evidence before you at all, other than Jordy, that says that Tabito was reluctant to leave. I mean, he was killed outside. So he did leave. But yeah, he was coming out for Jocelyn. Mr. Warner was correct. He was chasing Jocelyn with that gun. And he may have killed her. And here's something that I think about, is if he had gotten his way and gotten away with this, I would fear for Jocelyn's life. Because he would know that all it would take was for her to go to the police at any point. If he ever upset her, if he ever beat her, if he ever treated her badly, she could go to the police and he'd be arrested for murder. That would have been a very dangerous position for her to be in if he got away with it. But he came out there intending to use the gun. He told you that. He grabbed the gun because he intended to use it. And he comes out and he's confronted, not confronted in a violent way, but confronted visually by seeing Tabito there, the guy that has hurt him so recently. And that's when things went south. And Jocelyn says that they were walking to each other when she last saw them, and they were talking to each other, and I'm sure they were. Jake, could I get you to put Exhibit 19 up, please? zoom out. All right. So that mop is Jordy's door. He comes out, and Tabito and Jocelyn are over by the car. The facts that we have in this case, the physical evidence, do not match anything that the defense has brought you. How did Tabito's body get way down there? I can tell you what happened. Jordy says, get the hell out. He says, I'm waiting for my Uber. Jordy racks the gun. I'm not kidding. The bullet flies out. Show me he starts walking towards him, racks the gun, the bullet flies there. Gets closer to Tabito. Tabito turns to run and is shot in the back. I mean, that's what happened here. Now, we could quibble. We could try to split it atom and say, you can never be sure. But we know this is what happened. We know that this man was executed. And we can't allow legalese and micro-parsing facts to allow this man to get away with it. I want you to take your charge responsibly. I want you to be absolutely sure in your heart. What I'm telling you, we have brought you the evidence that clearly establishes beyond a reasonable doubt that Jordy Estrada killed Tabito Velasquez. And every other element, as Mr. Worley told you. He intended to do it, he did it. I mean, just the fact that the gun was out is proof of intent. Just the fact that the gun was aimed in the direction of Tabito is proof of intent. We can't climb inside his mind, and we know he's not going to get on the stand and tell us the truth. So we've got to look at all of these facts, and when you put them all together, they lead to only one conclusion, and that is murder. Jordy is guilty of murder. I ask that you please think responsibly, go back there and do your duty, and come back with a verdict of guilt.
All right, ladies and gentlemen of the jury, you are excused to the jury room to select your presiding juror and begin your deliberations.
All right.
Yes, sir.
How long do we have until we be dismissed for that?
That's up to you. One thing I did forget is I need you all to leave your notes right here.